Directors of Public Administration International you have heard from, and her colleague Amanda. My name is Neil McCallum, as you've heard, and I work with PAI as a director of programs around judicial administration and transforming criminal justice. And I'm delighted to be able to tell you that we have 3 guest speakers with us, and you will be hearing from them on particular aspects of the areas that we're going to be talking about. They are Lloydette Byamaro, Edward Bloomfield, and David Abbott, all of whom contribute to our programs at PAI and have a remarkable background, which I think you'll find gives them really valuable insight. I look forward to them sharing that, and it's a real pleasure to have them with us, as it is to have you with us. So thank you very much. We have people not quite as generously as this map perhaps suggests at the moment, but we have a large number of people registered for this from around the world. Not all have joined yet, but we look forward to more people joining as we talk. And this is the second time we have carried out this webinar. And the engagement between people and among people who've registered has been really quite remarkable at the previous event. And I hope that you will find that useful as well. So what are we going to do today? Well, we're going to be together for around an hour. We won't be absolute about closing down exactly 1 hour after we started, but we anticipate that this will be around 1 hour. And we're going to focus on 3 specific issues. 1, solving the immediate problems that judicial systems are facing around the world. 2, wondering if there's an opportunity to create a better future to come out of this terrible time, and whether there are things that we can learn, things that we can change, and whether this period prompts us to think in different ways about the roles that we have. And then to ask, what can judicial officers, judges, registrars do, and what can judicial administrators do? And we'll do that by discussing these issues. I will talk for a short time, and then I will ask our various speakers, one after the other, to contribute at their respective sections. We're going to ask you a couple of questions to garner opinions from around the world on a couple of issues. I'm going to suggest to you 3 key principles which inform my perception of this current situation and ways forward. Our guest speakers will speak. We will have a question and answer session, and we will at the end invite you to review this event and suggest any potential for further discussions. If you have questions, by the way, please send them in at any point. Don't wait till the end if you have a thought or an observation. And if you have a question for a specific speaker, then please flag that with their name. Otherwise, we will attempt to answer your questions as best we can, depending upon its area as to which one of us will do that. So the first of our 3 themes, solving the immediate problem. It seems to us that there are 3 main challenges here. 1 is clearing the backlogs which are building up in all of our systems inevitably. 2 is resolving the consequences of lockdowns and the way in which our societies have changed very rapidly, hopefully temporarily, in a very short time, and the extent to which our systems can keep up with that and respond to the new challenges that raises. And 3rd is the question of how we just do our job in an era of social distancing and the challenges that we all face. We will then look at creating the better future and wondering if there are opportunities to build something more positive or more robust for the future. And then considering this question of who can do what. But first, may I ask you to share some information with us? As Amanda mentioned, we have 2 polls during this event. This is the first. Could I ask you, please, to identify where your jurisdiction is today? So I've given 4 options. The first your courts are closed and staff are at home, furloughed, or not engaged in any work. Second, your courts are closed, but your staff are working, either in the building, but no hearings are taking place, or at home through remote working arrangements. Third, your courts are working, but with restrictions on their activities. And then finally, the courts are fully open to the public in your jurisdiction. So if you'd be kind enough to please to just identify which of those four descriptions most closely resembles where you are at the moment. Okay, we've still got a few results still coming in, but basically most people are in the middle two categories. Courts closed, but staff working, or courts working with restrictions. And we'll focus our comments very much on that fact. So thank you very much for that. And we may return to that when we've got all the results in. Thank you very much. So, the first of our challenges of the present situation, backlogs. Now, backlogs, as I'm sure are all well aware, are not new problems for many jurisdictions. And there are strategies that have been used effectively around the world to attempt to clear those backlogs. And I think a good starting point for the present situation is to look at some of those strategies and to see what could be applied now. Now, we could run an entire webinar on dealing with backlogs, and who knows, maybe we will. But for today, I would suggest that there are three issues to think about. One, to divide the strategies to be applied between the judicial, the quasi-judicial, and the administrative. That's to say, identify what needs judges to do things, and then explore whether there are ways in which the processes which get the judge to a situation where they can make a decision or take the next action can be streamlined. Is it possible to expand the number of judges that you have through, as it's been done in other sectors, asking retired personnel to return, whether there are ways around simply expanding the judicial time that you have available. Whether there are actions which quasi-judicial officials can carry out. So, for example, can registrars, etc., be given extra powers in the short term to act in particular ways? And then what can be done administratively? And I would suggest that that third area is often one that is overlooked or underexploited. I've seen quite remarkable changes being made to delays and backlogs by some really fairly simple administrative actions. In one jurisdiction in which I worked, backlogs were reduced to less than half by the simple expedient of having judicial administrators contact parties and check what the latest status of the matter is. And a significant part of the backlog turned out to be matters which had either fallen by the wayside, been resolved by other means, or which parties no longer wish to pursue or were willing to consider ADR, alternative dispute resolution, now when they weren't earlier on. So there are quite a lot of things that can be done, and there's a lot of learning around. And if it's an area which people are particularly interested in, we can share more about experiences elsewhere. Consequences of lockdowns. We need to think about the different ways of working, changed priorities, and whether there are new offences that we need to consider. And I would suggest that among different ways of working, we have seen virtual courts, judges sitting alone, where in the past they would have sat as a bench of maybe 3, or smaller benches so that social distancing can be achieved in the same space. Shift working, so courts functioning with, say, only half of the courtrooms open at any one time to minimize the number of people coming in. One approach I just heard about a few days ago is to change the listing system so that all the cases relating to a single chamber or solicitor's practice will all be heard at the same time. So rather than the kind of changeovers that we very often see in our courtrooms, we focus not on the matters so much as the lawyers who are going to be presenting them, so that when lawyers come to court, they deal with all the matters that they're going to be handling on that day or over that period, and then they go away again. And there aren't lots and lots of lawyers coming into court for relatively short hearings. Much greater online dispute resolution. Diversion is an approach which predates the current situation in many countries, where we simply try and stop matters entering the judicial system at the outset. And in a number of countries, and England and Wales certainly are among this list, we really question whether things which maybe traditionally we've tried to get the criminal justice system to deal with can be dealt with better through other routes. And perhaps a dramatic example of that is our approach to prostitution, and to some extent as well our approach to domestic violence situations. Again, this is a huge, big area, but whether there are ways in which we can stop things coming in, and this leads us on to on-the-spot fines and fixed penalties. But of course, all these things offer us opportunities, but they carry risks and present challenges. And if we are giving greater power to law enforcement to be effectively both all of law enforcement, prosecutors and judges, and are empowered to execute their own judgments, of course that carries risks. And if ever there was a time when questions about law enforcement and the powers and the accountability of law enforcement were on the world's minds, then this certainly is one. We see virtual courts already functioning. The top image I present here is of an experiment in the UK, the lower image of the first virtual court functioning in Nigeria. Unchanged priorities. In many countries, starting in Wuhan in China, and I think pretty much reflected wherever I've heard about it, and certainly again in the UK, incidents of domestic violence have dramatically increased. Should this mean that we change the priority that our jurisdiction gives to those matters compared to the way in which we handled them prior to this situation? The way in which we handle vulnerable people is a concern for many jurisdictions. And should we be changing now our definition of what constitutes a vulnerable person to include those who may be shielding or particularly at risk during this present situation? Family matters, the complexity of divorce and access to children have to be a huge concern for many of us, and how we achieve that whilst achieving the broader objectives of lockdowns and social distancing. Should we take a different view on attacks on key workers? The fact that the accused person in any matter is in custody and those custody periods pre-trial are probably going to be a lot longer now. What issues, what questions does that raise for us? Should we have new offences? We do indeed have some new offences in many countries, breaking lockdown restrictions, and how that should be handled by the system. Should we have new offences around issues like profiteering? Imagine a trader who buys a box of 100 masks or 100 gloves at $20 and then breaks them up and sells each one individually for $20. Is that a smart businessman? Is that sharp business practice? Or should that become an offense? These are questions every society, every jurisdiction will need to consider in their own way against their own priorities. But they are things which I would respectfully suggest the kind of people who are attending this event should be part of that conversation. All of this is against a background of the fundamental principles of justice to which we all, in different ways, have signed up. The critical importance of a judiciary, independent and uncorrupted, the right to confront your accuser is perhaps one of the key things which is under threat is probably the wrong word, but challenged by the realities of the present situation. The presumption of innocence, the right to bail, the right to legal representation, and the right to a speedy and fair trial. These are principles which jurisdictions have adhered to for decades and centuries. To what extent are these now under threat, and to what extent should we be willing in the short term to trade some of these principles away? And so I'd invite you, please, to engage in our second and our final poll. And I'd like to ask you which of the two statements, A or B, most closely reflects what you think. Now, you will rightly probably say these aren't mutually exclusive, and that most of us will feel the answer lies somewhere between the two. But if you had to choose between one of these two propositions, could I ask you which it would be? So A is the principles of justice are too important to be altered to meet a temporary crisis, no matter how serious it is in the short term. Or do you agree more with B? The current crisis calls for radical changes in the way justice is delivered. And again, if I could invite you, please, to select between those two statements, that would be very helpful. Okay, just looking at the results that we have. And interestingly, the majority of people seem to feel that the second of those statements are the most significant and the most important. Thank you very much indeed for that. And that actually matches the thinking that emerged at our first webinar on these issues. So I will offer you now my first principle, which should affect, I believe, how we move forward. And that is that social distancing shouldn't mean greater social exclusion. Most jurisdictions, if not all, struggle with the concept of access to justice, equality, and equal access to justice before the law for all its citizens. And there is a danger, as we move into more virtual hearings, greater reliance on technology such as we're using today, that we create a new digital divide. And I would like to invite the first of our guest speakers, Lloydette Baimaro, to reflect upon these issues. Now, Lloydette is a very experienced prosecutor, investigative prosecutor, having worked with both our Crown Prosecution Service, our state prosecutor in England and Wales, and with our Serious Fraud Office. She works for a major US company as counsel and has led numerous projects overseas, particularly in Sierra Leone with the Anti-Corruption Commission, and is a visiting lecturer at the Anti-Corruption Academy in Vienna. And I'd like to invite Lloydette to share some thoughts on these issues. Lloydette?
Hi, Neil.
Hi, Lloydette.
I'm just switching over to my video. Hope you can all see me. Here we go.
Hey,
hello. Hi, can you see me? Oh, excellent. Good morning. Well, it's good morning here. Good morning, everybody. I just wanted to say thank you to PAI and to Neil for the invitation to speak today. What I'm going to cover in my very quick presentation are just 5 different areas that I wanted to touch on. The first one follows very neatly on from Neil's last point about the digital divide. When we talk about the digital divide, we're really seeing the exposure in relation to those who have technology available to them right now and those who don't. The question that is facing many people is, well, actually, do we have the technology? Can we afford the technology that we need to be able to get up to speed? We're seeing a divide between those countries in the developing world and those in the developed world. In some jurisdictions, for example, right now, their courts have ground to a complete halt because they are purely paper-based system. And some of them are trying to catch up by investing right now in the technology that is needed to get their courts online to some degree. Neil's already mentioned that we have virtual hearings going on in some countries in the developing world, such as, India and Nigeria. And we're seeing issues in relation to, well, where there are issues with the digital divide, well, what are we talking about in relation to access to technology for defendants, access to technology for victims and witnesses and claimants in civil matters? Because it's not just about the court having the equipment, it's also about the individuals being in a position where they can access the technology too. And not everybody has an iPad or a tablet or a laptop or even a smartphone. Those are things I think sometimes some of us take for granted, but actually in this pandemic season, it's actually exposed some of those great inequalities. I read recently that there was a fact that 21 million people in the US don't have access to high-speed internet in the USA. And I take Wi-Fi for granted. And this is a major hindrance to access to justice. I wanted to move on to touch on very briefly on common law versus civil law jurisdictions, and how those 2 types of jurisdictions are adapting to virtual hearings. What we have seen is that the transition for civil law jurisdictions has been actually much easier than those in common law jurisdictions. The reasons being, civil law jurisdictions tend to be, their hearings tend to be less theatrical, they are shorter, they're less reliant on the role of witnesses, and the style is certainly not adversarial, it's more inquisitorial. And so for those of us who are in common law jurisdictions, who relish the thought of being advocates in the courtroom and the flourishes that come with that, we're facing having to be far more focused as to how we investigate, how we prosecute these cases, focusing specifically on the most important elements of the cases, especially especially right now when we are in the season of having online courts. We don't have the luxury of being in a courtroom for weeks on end prosecuting a case. So wanted to talk a little bit about open justice. So the question I wanted to address is, well, how can the public participate in in open justice. You know, we know that open justice is a fundamental principle. And prior to COVID, if individuals wanted to see a case, they could walk into a courtroom in any country and sit down and listen to the case. Well, certainly in this jurisdiction and many others. And now that doesn't happen. There are no physical courts actually operating in a lot of jurisdictions. What we have seen is that, for example, the technology is allowed in some jurisdictions, for example, Zoom, you have some jurisdictions have the ability to admit as many as 500 people into a courtroom hearing, which is massive. You know, most cases, you're not going to have 500 people turn up to watch it. You also have things like YouTube and Facebook where courts are live streaming their hearings, which again are great things. It does give access to the public. We know that the UK Supreme Court has done this for a number of years. They've been live streaming their cases, and what we're seeing is other countries follow suit. However, there are issues in relation to access. Internet speeds mean that some people may not be able to watch the courts live streamed or actually access the recordings. We also have issues in relation to how other jurisdictions who were not previously live streaming are now coping with going into that new arena. So I wanted to give you an example that at the beginning of May, the US Supreme Court made history by holding its first ever oral argument via conference call. And that was streamed online for the first time. And overall, this was a great success. However, there was an interruption during that hearing, submissions by one of the counsels, by somebody flushing the toilet. It remains a mystery as to who the flusher was, but it gives you a flavor of some of the challenges that we have. People recognizing that actually just because you are sitting in your home does not mean that you're not in a formal environment, and to remember the rules that go with that. I finally wanted to touch on two things, which are jury trials. We've seen that virtual hearings work very, very well for pre-trial hearings and also for shorter matters that normally less than a week or 2 weeks. The biggest challenge is when we come to jury trials. Jury trials in many jurisdictions are not that easily adaptable. And there are large backlogs now in this jurisdiction and in many other jurisdictions when it comes to jury trials. Some jurisdictions are currently considering implementing judge-only trials in some cases, and there are a whole raft of measures. In the UK, what we're also considering is something called Nightingale courts. So we've had Nightingale hospitals, which were built to respond to COVID. There's now a consideration of using different types of venues to hold hearings at an appropriate social distance, et cetera, so we can get over the backlog. For complex cases of fraud and corruption, which is my area, that's a major issue because our cases tend to last for many months, often in court, and keeping a remote juror focused, keeping them from not checking their phones and checking WhatsApp and checking social media can be a massive challenge. And so those are some of the hurdles we're going to have to get over. And the final thing I wanted to mention was the human element. What some research has shown is that about 10 years ago, some research was conducted which showed that we treat people more poorly over the internet than we do in person. So the question is, what are the implications of that for online courts where people's lives, their liberty, their finances are at stake? When you factor in other disparities and unconscious bias, that research could be actually really significant. You know, are we going to see online courts be a place where there is an empathy deficit? Does it make it easier for a judge or a magistrate to sentence someone to an extensive period in custody because they can't actually see the person in front of them? Those are questions I think that hopefully we'll be able to address in this webinar. So to conclude, the justice system in many jurisdictions is woefully behind. We've really resisted changes in terms of technological advances, but the pandemic has changed that. Virtual hearings really have a great deal of value in our post-pandemic reality, but there is a massive risk of over-reliance on virtual hearings, and access to justice should not be dependent on access to technology. So Neil, I'm going to leave it there and hand back over to you because I could probably talk for another 15 minutes. I look forward to any questions that you may have later on.
Wow, thank you so much, Lloyd. Absolutely. And the only thing I would disagree with there is your statement that you could talk about that for another 15 minutes, because I think there's a couple of hours worth at least of really important things there. Some really challenging and some really important issues raised. Thank you so much. And I'm sure there'll be lots of questions, and I'll invite our participants to reflect upon what you've said and to look for issues that they would like to explore with you. So thank you again. Let's move on to the next of our themes, our three themes: creating a better future. Other lessons we can learn from one another and from elsewhere. And I'm going to immediately hand over to our next guest speaker, Eddie Bloomfield. Eddie Bloomfield has had a long and distinguished career in our Ministry of Justice, particularly focused around court administration and the running of the system, and is now a non-executive director of a National Health Service Trust. And I'd be particularly interested to hear whether Eddie has identified in his current work with the health sector issues which could be of value to the judicial sector. So, Eddie, I hope you're with us, and thank you very much.
Next slide, please.
I hope that's there, and I'll switch my mic off and let you speak.
Just doing that for you now.
Yeah, can I have, thank you. Do you want to hand over now so that you can have me on camera, please?
Yeah, baby, for 1 second.
Thank you, and thanks for that introduction, Neil, and hello to everybody. Yes, I have got a background, a considerable professional background in the justice service, but I retired a couple of years ago, and since then I've been a non-executive director of my local National Health Service Trust. So what I'm hoping to do in my short session is really to offer the judicial system some learning from other sectors, and in this case it's health. Just a little bit of background. My NHS Trust contains 2 large district hospitals. We've got about 10,000 staff and an annual budget of around £750 million. And we serve a population of around 1 million people in the east of England. And for the last 12 weeks or so, we've been in the response phase to the COVID pandemic. And during that time, we've sadly seen over 300 patients die, and we've lost 3 members of staff. But I'm glad to say that the numbers are coming down now, and we're moving into the recovery phase, where we look to restore our services, many of which have been put on hold during this period. And I'm the lead non-executive director for that work. So what I want to do is offer you just a few points of learning, really, that I've had from the first few weeks of trying to recover, restore and reform our services in the hospitals. So the first thing I want to talk about is rebuilding confidence. Confidence has been shattered by this COVID pandemic, and people are frightened and remain frightened. We really need to focus on making sure that staff, in my case patients, or in the case of the judicial system, staff and court users, feel confident that if they have to come into the courts, that they will be safe. Now, how you do that will vary. What we've tended to focus on in the hospitals, understandably, are issues like personal protective equipment, testing to so that we can be sure that our staff are not COVID positive, and in particular communicating what we're doing to our patients and to the wider population, because people their behaviours have changed dramatically during COVID. So, for example, accident and emergency attendances are 50% down. Cancer referrals are something like 70% down. And a lot of this will be because people are nervous or worse, frightened about coming to the hospital. But what that's doing clearly is storing up problems for the future. So I'm encouraging you really to think about how in your particular systems you can rebuild confidence. And obviously one of the key points in doing that is social distancing. So here in the UK, we have a 2 metre rule. Where people have to keep a 2 metre distance, and we've done a lot of work to redesign our sites to enable the social distancing to take place. Just to give you an example of that, prior to COVID, of the impact of that, prior to COVID, we could see on any given day around 1,200 outpatients, and with social distancing in place in our 2 sites, we can only see 500 outpatients per day. But the important thing is that we're communicating with our patients and people that have to come to the hospital that we have got social distancing in place, that we will be following the rules and doing everything we can to keep them safe. And of course, in that point, there's also something about staff culture, because certainly in the NHS, the culture has always been very much a culture of people clustering around a bed or around a computer. And it's really important, and I think this is important for judicial systems as well, that the staff who are actually delivering the service model the right social distancing, so that when court users come in, A, they see that it's being modelled by the staff, and B, they follow it themselves. The next point I want to talk about is the importance during this recovery phase, when services are being restored, of taking the opportunities for reform. So all organisations will have found that things have had to change dramatically because of the pressures of COVID. And some of those things we might want to keep, we will want to keep them. And I'll give you a couple of examples from my experience with the health service. One is in terms of attendances. So we've got introduced a system called Attend Anywhere, so that virtual consultations can be carried out. Now, pre-COVID, they were running at about 5% of the total. And during the COVID period, virtual consultations have been 65% of the total. Now, we clearly won't keep it at quite that level, but we've identified huge benefits from that, not least for the patients themselves, in terms of not having the stress of coming into the hospital, which, as I said earlier, is a big thing at the moment. But even in the past, pre-COVID, it could be quite stressful to visit a hospital, trying to find parking, sitting in the waiting area, those sort of things. And all of that is eliminated by virtual consultations. And it's also helping us, of course, to cope with the requirements of social distancing, where our capacity to see outpatients has been considerably reduced. So that's one example. The second example for reform that I would highlight is remote working. And again, out of our 10,000 staff during COVID, we've had around 1,200 working from home. And we surveyed them to see how they felt about that. And 90% were happy to continue working from home in some shape or form, not necessarily full time, but some of the time. And of course, you can do that. That again allows the capacity to build the social space that we need for safety of our staff and patients. And then the final lesson that I want to kind of offer you this morning for your own plans to rebuild and recover is the importance of communications and staff engagement. If you're going to rebuild confidence in staff and users, you really need to tell them how you're doing that. So it's really important to communicate effectively what's going on to build that confidence. And also to engage people in it. I'm really kind of advising you not to have a top-down approach to recovery. Engage with staff, find out from them what they're worried about, see how that can be addressed, find out from them what they think has gone well during the COVID period, and make reach your conclusions about whether you want to keep those things in place. It has been a terrible time, but as always, these times do offer opportunities. There can be some positives that will come out of this period, and I would encourage you to think about those opportunities as you go forward with rebuilding your judicial systems. Thank you very much for your attention. I'm staying on the webinar, so if anyone's got any specific questions, I'll be happy to answer them at the appropriate time. Thank you. And Neil, I'll hand back to you there. Thank you.
Thank you so much, Eddie. There's some really important things in the areas that Eddie has covered, and he has direct personal experience, I know, of leading a very complex and potentially very, very difficult and painful change process in the justice sector. And many of the things that he talked about there around communication, staff engagement, I know is something that he has championed very much. I think what Eddie said around clustering as well, I totally recognize that from the health sector, but I think also, as Eddie says, in the justice sector, we see that. And modeling behavior has to be one of the most important things that we can do. We might return in the discussion section to your point, Eddie, and the point that Lloydette made about the way in which engagement virtually is different, much less intimidating in some cases, but also there is a real danger that the seriousness, the gravity of the matter maybe can be lost. And as with all these things, it's a balance, but it's really important. Thank you so much. Right, one final thought from another sector, and this is a quote from the UK's Secretary of State for Transport, and I make no judgments because I'm simply not qualified to, as to whether what he was talking about is accurate. I'm sure it is, but it's this statement that I want to focus on because I think there's some really important thoughts in this statement. And he said at the daily COVID briefing, almost a month ago now, amid all the sad news and the tragedy of loved ones we've lost, we've somehow managed to do things in weeks that would normally take years. Building new hospitals, moving public services online, making instant reforms, and fast-tracking new laws. And I think particularly the point about this situation has forced upon us changes and the need to respond to changing situations much more rapidly. And there is hopefully some good long-term that can come out of that. And I think that's what we need to, as far as possible, focus on. My second principle, and this is a very personal one to me, is to remind ourselves that not every significant change requires primary legislation. This is significant to me because this is a mistake that I have often made in my work around the world. And I have been surprised how often the assumption that I've made that, well, obviously this requires an act of parliament has proven not to be the case, and that existing legislation empowers a great deal of activity. Maybe it needs secondary legislation, but I've been surprised how often important changes do not require primary legislation. So that leads me on to the third area that we are discussing today. What can judicial officers do and what can judicial administrators do? And for judicial officers, judges, registrars, then there may be areas which can be looked at now on the list of things which have often been something that we'll leave for another day, or a bit too complex to handle now, or when we've got time. Because one of the impacts of our courts being closed or significantly reduced functioning is there is thinking time. Court rules. Can court rules be re-examined to remove activity which is no longer necessary or appropriate, maybe long-term, but certainly short-term? Are there procedures that can be brought in to address some of the issues which both Lloydette and Eddie have talked about? Are there instructions that can be issued which empower others in the system to take useful actions to meet the current challenges? And for judicial administrators, there are key issues around the management of the court buildings themselves, in particular access, choke points, and risk assessment for everyone involved in the system should be a priority. And Eddie's mention of clustering is exactly the right word to think about in these terms. The delivery of justice is a business which has traditionally involved often lots of people in situations of stress and drama and crisis in confined spaces. And these are just two images, but we will have seen things like that. We'll have always seen courtrooms empty with very few people in, but also there are often high-profile matters where managing clustering, managing people is the major challenge. And there are obvious high-risk areas. Entry, how we balance when we carry out searching of people entering court buildings, if that's part of our processes, how we balance social distancing, human dignity with effective security. Most of our custody suites, the cells, often below courtrooms or in court buildings, have certainly, I've never seen any yet, which have been designed with social distancing or anything like it in mind. They tend to be very small areas, very confined areas, with people being very close to one another. Lawyer-client consultations, how those are carried out whilst confidentiality is protected and observed. These are areas which are primarily, I would suggest, for administrators to solve. As with many things, nothing is new. These are challenges which have already existed. This is some information about the Supreme Court in India. And we will, again, all have seen and worked in and been in court buildings where there is just such a mass of people moving around. And I think fairly recently, the Chief Justice of Nigeria closed down a hearing and returned to his chambers because simply the sheer amount of people in the building, in the corridors, made functioning simply impossible. So these are things that have happened before. There are approaches, and I think there's great opportunities here. And there is good practice developing around the world, which is publicized and shared, and we can all access. My third, and you'll be pleased to hear, final principle is court administration can always be improved. If anyone feels that they could say in their jurisdiction, the way their courts are run are absolutely perfect and could not be made better, I would love to know about that and to see that, because I think that in reality, every system can be improved, and court administration certainly is one of those. And so that leads me very neatly to invite the last of our guest speakers, David Abbott, to join us. Now, David has a background, again, in the delivery of justice in our system, also with looking at the way courts can change to meet the challenges of the modern times, and still working in this sector on various agencies, now in the NGO sector, but still working around the justice system. And David has great experience and great knowledge of new ways of working within justice. And David, if you would be kind enough to talk to us, we'd be very, very grateful.
Thank you very much, Neil. I think this crisis has demonstrated, oh, sorry, I'm just going to switch my video on. There we go. Good morning, everybody. This crisis demonstrated that it's maybe only heightened many of the issues that were already latent within our justice systems. And so we're trying to recover from the impact of the crisis while still kind of trying to fix many of those issues that were already around and are pretty deep-seated, actually. And I think for that reason, we can't provide easy answers for you in this webinar or in these kind of sessions, but I think we can suggest areas of focus that would be profitable. And I'm just going to touch on 3 areas. One is the use of technology in court administration, secondly, communication, and thirdly, the need to kind of get the basic underlying systems as good as they can be. So very quickly, in terms of technology, we've already heard about the use of technology in the courtroom. I don't think technology is a panacea for all the issues in our justice systems, but it does offer a range of new tools that we can use and we can adapt and we can maybe use proportionately. So I think in terms of court records, we can look at what you can actually digitise, and that doesn't have to be all singing, all dancing systems. It is possible to digitise elements of justice systems and maybe digitise things in a modular way and then build up gradually over time to having completely electronic systems. But it's I don't think we need to be put off from attempting this challenge just because of the size of the challenge, and so small chunks. So in terms of case management, these days there are many off-the-shelf case management systems. They'll all have their respective merits, and no doubt you'll maybe have thought about them if you've not already started to use them. And I think there's a wealth of support out there now in the justice community. And so, for example, I point participants to this webinar to a website which is remotecourts.org. And I'm sure we can follow this webinar up with a reminder of that website. So this is people from justice systems all across the world posting their experience of introducing technology and using it. And so there really is a wealth of support out there at the moment. And then moving on to, for example, the electronic presentation of evidence in the courtroom. I think in time, this will be where justice systems end up, but I don't underestimate the scale of the challenge here. And I think maybe interestingly, there are opportunities initially at the kind of the higher end of justice systems, and also maybe some of the more straightforward cases. So at one end of the spectrum, you have large cases, maybe fraud or corporate cases, where the parties are represented and they maybe have good access to technology, and technology can be used very effectively in those cases. But actually, at the other end of the spectrum, some of the more straightforward cases or maybe regulatory type cases can also lend themselves very effectively to the electronic presentation of evidence. I'm thinking here of things like even parking violations, that kind of thing, where there's relatively straightforward facts and opportunities for people to speak in the trial. And I think the second area that I'd really want to focus on here is absolutely essential, and Eddie's touched on this already, but it is actually prioritising communication. I think we're only going to get through this crisis and the aftermath of what we're all experiencing if we do make sure that we communicate at all possible opportunities. I would argue very strongly that justice is of interest to the whole community, and the whole community needs to be involved in discussions about how to move our way out of the immediate crisis point. So I would argue very strongly that consultation with stakeholders is really important, and a sense of inclusivity to restore that sense of confidence in the justice system. And to go into maybe a lower level of detail, I'm sure we've all experienced those times when there have been maybe backlogs or delays in our systems. And one of the first things that happens is when there have been delays, that people get concerned about their case, about the progress, and they then call the office and ask questions about where their case is up to. So it's far better for court administrators to be as proactive as they can with administration, because that then cuts down on productive tasks, such as dealing with phone calls from people. And so if it's possible to enable self-service, maybe by using technology, so that clients, court users rather, can understand for themselves where things are up to, there's a lot of increased productivity from that. And then the third and final area I'll just touch on is really reviewing the way that we do business. Now above all times is the need to be as efficient as we possibly can, to squeeze every ounce of value from our justice systems. And I think now above all times is the time to process map the way that you do business, and to remove unproductive tasks, maybe the things that have been done like that for years and years that haven't quite kept pace with developments. Now is the time to remove all of those kind of wasted resources from our systems. And within that, I think it's also important to maximise the use of management information, so that everybody has a really detailed understanding about where cases are up to, what's causing barriers, and how to move things forward. And then the final thing I would just talk about is whether our administration structures themselves can be reviewed. And there is an argument in some jurisdictions maybe for separating the handling of new business as it comes in from the handling of the backlog of cases. And I think there are interesting discussions there to be had about whether teams can be reconfigured so that new business as it comes in can be dealt with effectively, to restore a more immediate sense of confidence in the justice system. As with our other speakers, I'm also happy to deal with any questions, and I'm going to hand back to Neil at that point.
Thank you so much, David. Thank you so much, David. Absolutely hugely important issues. And I think from all of us, a theme I hope that is emerging is this issue about communicating. And I think that the justice sector, despite many good efforts to achieve it, is remarkably poor at communicating and keeping people up to date. And it is the key, as I think everyone has said, to moving forward in a way that maintains confidence and gains and keeps engagement. Thank you so much. And I'm sure there will be questions for you, as there will for Eddie and Lloydette. Right. What I would ask our participants, please, if you'd be so kind, is to consider what you think is the most effective thing that your jurisdiction is doing, or you think could be doing, to meet these challenges, and to share them on the chat. And certainly when we did this a couple of weeks ago for the first time, there were some excellent ideas and innovative approaches which colleagues around the world found very, very valuable. So please, while we're moving into the question and answer session, if you'd like to have that in mind, and if you'd be willing to share your thoughts on what your jurisdiction is doing, which you think is particularly effective or could be doing, that would be much appreciated. Okay, could I just ask Amanda or Denise if we have questions, and if you'd be kind enough to share them?
Okay, hello Neil, hello everybody. I'll read out the questions. So the first one that we have is a question for Neil.
Right. I think actually I don't need to ask you. I think I've worked out how to find them out myself. The new skills we're all learning. Okay. So I will go through. We have, excellent, thank you. We have 5 questions at the moment. Do please send any more in if you have them. The first question, Rachel, thank you very much indeed for this question. And the question is, thank you very much for your presentation, and thank you very much for being with us. Can I please ask, what jurisdiction is it you mentioned adopted some simple administrative tasks involving contacting parties. Yep, certainly I can tell you that. This, I was quoting work which was done in Nigeria in the Supreme Court, probably around 6 years ago, by one of the justices of the Supreme Court, Justice Tanko, and he basically, and I believe these are the correct statistics, but I wouldn't quote them without checking them. At the time, the backlog of cases in the Supreme Court of Nigeria was 15 years. And that was reduced to 7 years within a matter of, I think, about 3 weeks, simply by having court administrators phoning people up and contacting people. And as you can imagine, when you're talking about backlogs that long, a significant number of those matters were simply no longer there. The people had died, the matters had been resolved, or people had not wanted to pursue it. That raises its own questions, of course, about access to justice. And those delays are still a matter, as I know, of deep concern. I'm delighted to say that Justice Tanko is now the Chief Justice of Nigeria, and a great, certainly when I was working there, a great reforming influence. So Nigeria, Supreme Court. Next question for Lloydette. So Neil, if Lloydette, you'd be able to answer this. Again, thanks from Rachel. Can you direct Rachel, or all of us indeed, to more information regarding your point about the ways civil and common law jurisdictions have experienced this differently?
Hi, Neil, can you hear me?
I can indeed. I think we can all hear you. Please carry on.
Fabulous. A number of the law firms, the major law firms, have done some research in relation to this, obviously to help guide their clients through this process. So DLA Piper have written a fairly instructive report on this, but also I would recommend that those who want to have get some more details in terms of comparison, check out Professor Richard Suskind's Remote Courts Worldwide. So it's remotecourts.org. And there you will be able to get some commentary, you'll be able to get some user stories, and it's literally courts from all over the world sharing their experiences, both members of the judiciary as well as other court users, including obviously advocates, sharing their experiences as to how they've navigated, how they are navigating this new post or pandemic reality in terms of how remote courts are working for them. So remotecourts.org is one, and also check out all of the sorts of the major law firms in the UK and well globally have all written reports in relation to this.
Excellent. Thank you very much indeed, Lloydette. And if you could just stay with us, because the next question, I think you may well be best placed to answer, but obviously, Eddie, David, please do join in if you feel you would like to add to this. Charles asks, how do we handle evidence that can better be assessed face-to-face? For instance, injury inflicted on individuals.
This is one of the major challenges, actually. I think, again, we are going to have to be creative as advocates, using video evidence, making sure that, for example, if you're talking about physical injuries that have been inflicted, it may be that one of the ways that we do that is that we record the injuries. We ensure that actually, often in some cases, we would ask the person to come to court, but we might have to rely on medical evidence to confirm that those injuries were actually inflicted on that individual, and the nature of those injuries and the severity of those injuries. I think those are some of the more difficult things, because oftentimes juries, they do want to see an individual in person, and they do want to be able to hear from them. So not having that face-to-face interaction can actually not necessarily diminish the strength of the evidence, but I think it can make it a little bit more difficult to convey sometimes the severity of the issues.
Can I come in on that?
Yeah.
Yeah, so Neil, if I can offer kind of a parallel, my learning from other sectors point really. So, you know, if we think about virtual consultations that I was talking about, so what we are, I think, will adopt in the health service is a default position that the first consultation is video, virtual, unless the consultant decides that they need to see the patient face to face. So I suppose if I think about that in the context of the courts, it feels like there may be a default position that a hearing is virtual in a particular type of case, unless the representatives argue, presumably to the judge, that it needs to be in person, so that we at least, you know, reduce some of the time that needs to be spent on bringing people into court, but we retain the ability to do that on the merits of the facts in a particular case. So that's kind of the way we're doing it in the health service, and it feels like a very logical kind of approach for the courts as well. Thank you.
I think that's an excellent addition.
Thank you both very, very much. Right, I'm conscious that we are over our hour, but we have a couple more questions. So if you'll bear with us, we'll just address the questions that have been raised and then bring this to a close. The next point that's been raised is from Karen. Thank you very much, and good for you to be with us, Karen. We have to be very careful, Karen observes quite rightly, in allowing the executive to use emergency powers to reduce the powers of the judiciary. How do you reconcile lockdown and additional emergency powers with ensuring that human rights are still respected? Well, I think that it has to be a massively important thing for all of us. And we all have to recognize, without making any political statement here or any judgment on any particular country, history shows us that when emergency powers are introduced, it can be very appealing for the executive to make that the new normal. And I think that we have to guard very carefully against the new normal being a significant or even a minor change to judicial independence and the traditional role of the judiciary. And maintaining that boundary has to be a responsibility, I think, of all of us. If any of my colleagues would like to offer a view. Right, I'm going to be really mean now, not give you time to think about it. It is such an important issue, though, and I don't undermine the fact that that is a genuine risk in many countries. And there should always be a tension between the executive, the legislature, and the judiciary. That's the essence of the system. But that tension, that balance that comes from that tension, must not be allowed to move significantly towards the executive as a result of a short-term, no matter how terrible, short-term problem. Right, Charles, welcome. You have raised a very important point. Thank you for your second question. How do we eliminate the risk of bias from judicial officers, which could have been limited in an open courtroom where many people are present? Well, we've talked a bit about live streaming. Again, if any of my colleagues would like to chip in, please do. Justice is best performed in public. Scrutiny, I think someone used to talk about, was it the disinfectant of sunlight, the importance of things being done in the open. If technology can enable a court hearing, then logically technology must be able to allow public scrutiny. And live streaming, virtual public galleries should all be possible. But rather, like the point made by Karen, these are areas of risk that we need to be aware of. And I'm pressing the wrong button. Apologies for that. I should be pressing over here. Okay, and our final two, Afia, welcome, has raised the question, how would one suggest sentencing in serious crimes if COVID-19 is brought up? I'm going to allow Lloydette, if you don't mind, I'm going to give you a minute or two to think about that. So I'll just repeat the question. How would you suggest sentencing in serious crimes if COVID-19 is brought up? Because I'll move to the final question while you're thinking about that, and I'll just come back to Afia's.
Okay.
And Rebecca, again, welcome, says, I think for us in Ghana, we should improve our communication on what we are doing because of the COVID through our internal audio system and include some public adverts. Rebecca, if I could just say a particular welcome and a particular thank you for that point. I am currently working remotely with the Registrar General's Department in Accra and actually was in Ghana until the borders closed and I had to leave rather rapidly. I was very struck by, in particular with the Registrar General's Department, how rapidly they introduced controls on access, temperature checking, hand washing, mask wearing. And I think that the use of the superb communication systems that exist in Ghana is exactly the right thing. I know that radio announcements can be very, very effective in Ghana. And it does pick up on the point which Eddie and David both made, this issue about communication. It is critical. So I completely agree with your thought that more should be done about public adverts and telling people what's happening. Perhaps we could just return then before we close to Afia's point.
Yes.
Lloydette.
Hi. So one of the things that I wanted to address in relation to this question is, number one, I know Afia said, in relation to serious crime, but I think it depends on the precise nature of the offence or offences that we are talking about. Our sentencing guidelines in the UK, are comprehensive, and obviously they are going to have to be reviewed in the post-pandemic world that we're living in, or in the pandemic world that we're living in. I think that COVID, any kind of COVID information or submission will simply go to a mitigating point. It isn't going to be something that obviously is a defense of any kind. It's a mitigating factor that the advocate who is defending may wish to ask the judge or to consider, or a bench of magistrates to consider. And I think, it ultimately has to come down to the individual judge or bench of magistrates to decide on what weight they give to that information. Obviously, it could be a range of different things as to what they say, how COVID impacted on the potential offence. So I think it has to be on a case-by-case basis, recognising that it is something that you can consider in mitigation, and obviously be guided by the sentencing guidelines overall. But who knows what, COVID-related excuses or mitigation points will come up. I think there are so many different types. It could be that someone says, well, for example, as a result of suffering from COVID, I was infected with COVID, I've had some mental health problems or physical health problems that caused me to commit this particular crime. That's a significant mitigating factor. And if they can prove that in some way, then, that goes some way in thinking about how you then sentence them for that particular offence. So I think it's a juggle. It is going to be on a case-by-case basis. We don't know whether or not in this jurisdiction and in others that there will be some sort of guidance given in due course. The reality is that we don't know what the physical and mental effects of this particular disease are. We're still learning, and it may be well that people are able to mount a significant either defence or at least significant mitigation points as to how COVID-19 relates to their offending.
Thank you so much, Lloydette, and thank you to everybody who has participated in this event and the superb questions and discussions in the chat. And if at any point it looked like I was not paying attention, like I was doing this, it's because I was checking the chat room and the questions. Absolutely excellent. Thank you, everybody. Right. Well, I think this brings us to our close. I apologize that we've overrun, but that's about the quality of the discussion and the questions that were raised. So thank you for bearing with us. And thank you so much for some really important thoughts and valuable observations. Please do let us know what you thought of this webinar. Please let us know if there are topics you'd like us to cover in future webinars. And before I hand back to my colleagues in Public Administration International and Claire Cameron for any final words, let me thank you once again. Let me wish you all the very best, and please keep safe. Thank you very much indeed.
Thank you, Neil and Lloydette, David and Eddie, for the presentation, the thoughts, and for responding to those wide range of questions. Thank you, all of you, for joining. I hope it's been interesting and useful for you. Just to mention, our next workshops on judicial administration and on transforming criminal justice, which Neil leads, usually take place at our Central London Training Centre in September. We hope that maybe by then current travel and social distancing restrictions will have eased, but of course we're not sure. We'll certainly be including them in our 2021 schedule, so we'll keep you informed about that. For those of you who don't know, they offer a very nice blend of briefings, practical work, international networking, and benchmarking visits to counterparts in the UK public sector. And a good opportunity to update knowledge and skills in these really important areas. I hope that you may be able to join us. But above all, thank you very much once again for joining our webinar today. And to echo what Neil has said, please keep well and safe, and please keep in touch with us. Thank you, everybody.